Trust versus estate in New York. Side-by-side comparison. When planning for the future, New Yorkers often face the critical decision of how their assets will be handled after death. Choosing between a trust or an estate, or even using both, can significantly shape how efficiently and privately affairs are managed. Each approach carries unique benefits, structures, and limitations, and understanding the distinction is vital when creating a plan that reflects your goals. New York law. Trusts versus estate in New York. Both trusts and estates are legally recognized structures used to transfer assets. However, they function differently. An estate consists of the assets left at death, typically transferred through a will during a court-supervised probate process. In contrast, a trust is a legal arrangement that allows a trustee to manage and distribute assets, often without court involvement. A will only takes effect upon death and requires probate. Trusts, especially living trusts, can take effect during life and continue after death, offering ongoing asset management. Probate can be time-consuming, public, and costly, while a trust avoids probate, offering speed and privacy. New York law supports a variety of trusts, such as revocable, irrevocable, and special needs trusts, each with specific purposes from Medicaid planning to charitable giving. Trust versus estate. Which is right for you? Trust-centered plans are ideal when privacy, speed, and ongoing control are priorities. They're beneficial for high-value estates, those seeking to avoid probate delays, or families managing real estate in multiple states. Trusts also provide advantages for Medicaid planning, special needs dependents, or those wishing to control how and when assets are distributed. On the other hand, an estate plan centered on a will may be sufficient for simpler financial situations. Individuals with modest estates, minimal real estate, or a need to designate guardians for minor children often find a will appropriate. Wills also generally cost less upfront, although probate expenses may arise later. In practice, many New Yorkers use both, a trust to manage complex or valuable assets and a will to name guardians or handle residual property. How the process works. Trust and estate administration. Probate is the formal legal process where the court validates a will and oversees the distribution of the estate. It includes several steps: appointing an executor, notifying interested parties, paying debts, and distributing assets, all under court supervision. This process is public and can last months or longer. In contrast, trust administration happens privately and without court approval. When the creator of a trust passes or becomes incapacitated, the successor trustee assumes responsibility. They notify beneficiaries, settle debts if necessary, and distribute assets based on the trust's terms. Trust administration is often faster, avoids public scrutiny, and gives greater control, but trustees still have legal duties under New York law. Whether acting as an executor or trustee, the individual responsible must manage assets properly and be accountable to beneficiaries. Executors operate under court oversight. Trustees act independently but must still follow strict fiduciary responsibilities. Choose the right approach for your future. Making the right estate planning decision depends on your goals, family structure, and financial situation. A Long Island lawyer can help evaluate your options and determine the right mix of tools, whether a trust, a will, or both. The right guidance ensures your legacy is protected and your loved ones are supported with clarity and efficiency. To discuss your estate planning needs in New York, contact Schlessel Law PLLC at 516-574-9630 or visit us at 34 Willis Avenue, Suite 300, Mineola, New York, 11501, United States. A trusted attorney from our law firm is ready to help create a plan tailored to your goals. Let our law firm guide you through this important process with confidence.